everyone, and welcome to the REF webinar. At REF, our mission is simple: to bring the right people in the same room so better decisions get made faster. And today's conversations is one that too many people wait too long to have. Because in real estate and business, it's not just about how much you make, it's about how much you keep, how well you protect it, and how intentionally you pass it on. We've seen it time and time again. Successful investors, developers, and business owners building incredible portfolios, but leaving themselves exposed to unnecessary risk, taxes, and legal complications that could have been avoided with the right structure in place. And so today is about clarity. It's about control. It's about building not just wealth, but legacy. And to guide us through that, we've brought in someone who works directly in the trenches of these decisions that are being made every single day. So I'd like to introduce Anish Patel. Anish is an attorney with PSBP Law, where he specializes in estate planning, asset protection, and structuring strategies for business owners and estate and real estate investors. So he's not just looking at documents, he's looking at how people build, protect, and transition wealth across generations. From partnership structures and liability protection to navigating probate, taxes, and long-term planning. And each helps clients make decisions today that prevent major problems tomorrow. What I appreciate about his approach is it's not just theory, it's practical, actionable, and designed for people who are actively building. And Anish, we're so excited to have you. The floor is yours. Take it away.
Lillian, thank you for the introduction, and appreciate the background on it. Again, I am Anish Patel. I'm a managing partner at PSBP Law. Our practice areas are estate planning, asset protection, business transactions. I've been practicing for over 23 years, and over those 23 years, I've done a lot of estate administrations. I've done a lot of estate planning, wealth transfer planning, and the reason why I brought up the estate administration, there's a lot of attorneys out there that do estate planning. They print out forms and they fill it in, and they're like, "All right, here's the estate planning," right? But the key to if you're ever going to look for an estate planning attorney, the biggest key that I tell all clients is ask that attorney how many estate administrations that attorney's done. It's one thing to draft documents, but it's a completely different thing to actually implement those documents. I've been doing this for 23 years. I've done a lot of estate planning documents, and I've also been on the other end of it when that estate planning document is being implemented by that individual's spouse or children or beneficiaries. And so it's really important to draft the documents, but also see how those documents play out, which also gives me really good experience and to know what works and what doesn't work. So let's get started. We're here to talk about estate planning and what you need to know for estate planning. So today we're going to cover these 5 topics. 1, why you need an estate plan. 2, your options as an estate plan, which will be a simple will plan, the PSBP legacy trust plan, some estate tax and asset protection plans, and family LLC planning. Why you need an estate plan. The main reason you need an estate plan, or a couple of reasons you need an estate plan, is 1, to ensure that your family's the inheritance or assets that you accumulated go to the proper individuals, and at the end the person that is making sure those assets go to those individuals is someone that you have picked. Another reason you need an estate plan is to make sure that if something were to ever happen to you, God forbid, like you're incapacitated, you're in a coma, that the proper individuals are making decisions for you in those situations. And what's not happening is that a court is making that decision of who should make those decisions for you. Third reason you should have an estate plan is to look at asset protection. To make sure that a creditor's not going to, you're going to build all this wealth and accumulate all this wealth, and the creditor's not going to come in and take it from you. So what happens if you don't have an estate plan, you don't have a will? Well, one of the biggest issues when you don't have a will is your loved ones and beneficiaries are going to have to go through probate. If you don't have a will, the state of Texas has a will for you. Unfortunately, the will that the state of Texas has may not be in line with your distribution plan or where you want your assets to go. For instance, the big difference is most of my clients in their traditional estate plan, they have everything go to their spouse. But within the testate plan, that's not always the case. If you were to pass away without a will, it's split up between the spouse and the children. And if you have children from a previous marriage, it's split up even more. Another reason why you want to have a will is because probate without a will is difficult. What is probate? Probate's a process of going to a court and basically explaining to the court or basically telling the court that or asking the court to name an administrator for the estate, and then to also tell the court who the beneficiaries of that person's estate are, right? The court has no idea who the decedent is. They have no idea who that decedent trusts or who that decedent's spouse is, who that decedent's kids are. So when you have an estate administration without a will, the process is a lot more difficult, it's a lot more expensive, and it's a lot more timely. Again, spouses and children have to go to court and prove who they are. They have to prove that they have the authority. They should have the authority to take care of the estate administration. And a lot of times, courts aren't going to take their word for it, so they're going to hire an attorney ad litem, which is an additional cost. And so this just adds more fees and more hearings and more attorney fees and time to the estate administration. And this is not something that a spouse or the beneficiaries want to do when a loved one has passed away, right? Also, when you don't have a will, there's a good chance that there's no single location or there's no inventory of assets. When there's no inventory of assets, it's difficult for your loved ones to know what all assets you have out there. The last reason why you don't want to have a will you want to have a will is because you want to appoint a guardian for your minor children. This is probably the most important reason to have a will in place. If not for anything else, is just to make sure that your minor children are taken care of and taken care of by the right person. I also mentioned that a good estate plan should cover what happens if you're incapacitated or in a coma. Again, there's no automatic right for a spouse to make decisions for another spouse without a medical power of attorney or durable power of attorney. If you don't have a medical power of attorney or durable power of attorney in place and decisions need to be made, then a guardianship may be required, which is a court hearing. And a court hearing could be expensive and very timely. And it could also create an additional disagreement when there's end-life decisions. So if there's a situation where there's a terminal situation where a decision needs to be made to continue or discontinue life support, it could create a conflict. There could be a conflict between the spouse and the parents. It could be a conflict between the spouse and children. But these are all things that can be.
So you guys, once y'all get that from Paula, just sign off on it.
By power.
Yeah, we're supposed to know.
She has it in her hands, right?
Yeah, she has it.
She has it.
Sorry, I kind of clicked out of here. But the other big reason to have an estate plan in place is to make sure that the assets that you accumulated are protected and the inheritance that you are leaving for your beneficiaries are properly protected as well. So what are your options? The first and most important option that everybody should have is they should have a simple will in place. What does a simple will plan include? It includes a last will and testament. The last will and testament will tell the court, will tell the public who your executor is going to be, who the beneficiaries of your estate should be, and more importantly, who the guardian of your minor children should be. When you have a will in place and you go through probate, the court doesn't care about anything else at that point. The court has a document from you that says who your spouse is, who your children are, who should be the executor of estate, who should be the beneficiary of estate. So if anybody else comes out of the woodworks, they don't care. So that probate process with a will is a lot quicker when you have a will in place. A simple will also include a durable power of attorney. The purpose of the durable power of attorney is, again, if you're ever incapacitated, you're ever unable to make decisions yourself, it allows you to legally appoint an individual to make those decisions for you. And then that individual's decisions cannot be challenged at some point in the future. The other document that's included is a medical power of attorney. The medical power of attorney addresses who will make medical decisions for you if you're incapable or unavailable to make decisions for yourself. Again, the durable power of attorney is to address all decisions besides medical decisions, and the medical power of attorney decision is just for your medical power of attorney medical decisions. So what does a will do for you? Again, it ensures that your spouse receives all your assets and then your children, or ensures that whoever the beneficiary that you want for your estate will be the beneficiary of your estate. Again, it unequivocally lets the court know your wishes as to who should be the beneficiary and who should be the executor. Which in turn reduces probate fees, probate costs, and the time to do probate. It allows you to name a guardian for your children if something were to happen to you. And a good estate, the simple will plan will allow you to name your spouse or other individuals to make decisions for you during your lifetime if you're unable to make decisions yourself. Now, another option that I present to my clients, which is probably a better option for most of my clients, is the legacy trust plan. A legacy trust plan is everything that's in a simple will, but it allows you to do a couple of things that a simple will plan doesn't allow you to do. It allows you to avoid probate altogether. It prevents your assets and list of assets from being in public records, and it helps protect the inheritance that you're leaving your children. Again, when you have a will and you name your spouse and your children as beneficiaries, when that will is being probated, there's an accounting that's done at the end. And in that accounting, there's a list of all your assets. And that accounting is followed with the courts and is public record. So one of the ways that's avoided is by having a legacy trust plan. By having a trust, what you're doing is you're setting a trust up for yourself today. And with that trust, you're transferring all your assets into trust. You have full control. You're the creator of that trust. You're the trustee of that trust. You can amend that trust whenever you want. You can revoke it whenever you want. But it is in place today. And by having your assets in the trust and having full control of the trust then decides where your assets go and who transfer those assets upon your passing through the trust document. And with that trust document, you're avoiding probate. And when you're avoiding probate, you have continuity of business transactions. Again, your assets that are in the trust are not public records. And the bigger thing is that when those assets go to your children and or go to your spouse and to your children, they're now in a vehicle that can be protected from their creditors and from their spouse if structured correctly. A legacy trust plan, again, it will include the wills, it will include the medical power of attorney, include the durable power of attorney, and includes basically a irrevocable living trust. I apologize. I know I didn't mention this before, but if anybody has any questions in the interim, please ask. The third option that I talk to my clients about from an estate planning standpoint is more estate tax and asset protection planning. For a lot of my clients, they may not need this at this point. Unfortunately, the downside or the problem with that is when my clients do need this type of planning, it's usually too late or it's more difficult to implement. And it's easier to implement before maybe the clients accumulate the assets that they have. But a good layer approach for asset protection is, one, to always have good insurance in place, like liability and umbrella insurance in place. Two, to always have, a good business entity structures in place to protect your personal assets from your business assets and business liabilities. And then we also implement a family LLC planning and irrevocable trust planning. What is family LLC planning? Well, with that family LLC planning has been around for almost, probably since the 80s. In the original form, family LLCs was a family limited partnership planning. This planning had been used in the physician world, again, for almost since 20, 30 years, even to the point where a typical physician's practice has to be owned by a physician. The only exception in our statute to that is that it can be owned by family LLC. What does a family LLC do? Family LLC provides asset protection. It allows asset protection by limiting any kind of recourse for a creditor to a charging disorder or a charging order. And then also it limits even further because we're allowed to transfer some of that family LLC interest to an irrevocable trust. Two, it allows for discount valuations on gifts. When you're using family LLCs in an estate plan, when you're making gifts, instead of you're making a gift of the full value to a beneficiary or a child or a children's trust, that asset is discounted almost by 30 to 40% for discount valuation purposes. So when you're doing estate tax planning and you're close to the $30 million mark, when you start making gifts, using family LLC, you can squeeze the value of those gifts by putting assets into a family LLC and then transferring them to a trust. The biggest benefit of a family LLC is that it allows you to retain control and benefits of those assets while still giving them away. Clients call me all the time and they're like, hey, I heard that I can use an irrevocable trust to protect my assets. And I'm like, yeah, you can. You can move assets to an irrevocable trust. It'll be completely protected from your creditors. But guess what? You lost control of that asset and you lost the benefit of that asset. You can't be the beneficiary of that trust. You can't be the trustee of the trust. You can't control it. Someone else has to be a beneficiary. Someone else has to be the trustee. But if you couple that irrevocable trust with a family LLC, you can retain control and you can still benefit from those assets. And the way that happens is that the family LLC is set up where we have two types of ownership. We have voting ownership, we have non-voting ownership. You would retain the voting ownership and the non-voting ownership would be transferred to a children's trust or an irrevocable trust. Now, you retain control of that asset by having the controlling interest in that family LLC. You also retain benefits from the trust because you can pay yourself a salary from that family LLC. So even though the irrevocable trust owns, let's say 90% or 99% of that family LLC, you as a 1 or 2% owner of the controlling interest control 100% of all the assets underneath the family LLC. And again, you can benefit from it because you can still pay yourself a salary. So there are other ways to benefit it, if not through direct ownership. Again, when should you consider doing a family LLC? The earlier, the better. The problem with a lot of my clients who come to me after they've accumulated a lot of wealth when they're doing family LLCs is that we have to transfer your assets into the family LLC. And one of the biggest hurdles we have of transferring assets into a family LLC is they may have real estate or a building or some kind of property that's subject to a loan. And typically in that loan, there's a due on sale clause. So if there's any transfer of that asset to the family LLC or transfer of the LLC ownership to the family LLC, it triggers a due on sale clause. So what I typically tell my clients, or what my clients will typically do, is we'll set up the family LLC and we'll wait. to either until they sell that property and buy a new property, or they finance that property. Another hurdle that we have after my clients accumulate wealth or accumulate assets is there's a lot of times there's a restriction on transfer of business entities. So there might be a restriction on transferring of LLC membership interest or a partnership interest in an operating agreement, and that also prevents clients from transferring their ownership in certain businesses to a family LLC. The other thing is a lot of times my clients want to set a family LLC up when they're about to exit their business. The reason why that's usually the worst time to move an asset into a family LLC is because the purchase price of that business is going to set the value of that gift that's being made. If the transfers were done earlier, then all that appreciation and potential valuations could have been avoided by if done earlier. So it's always important to do the best time to do a family LLC is early, but typically again the issue I always come up with is a lot of times clients who haven't accumulated as much assets early on don't want to do a family LLC, and when they have, then we have these typical hurdles with a family LLC. So which is the right plan for you? For pretty much anybody and everybody, a simple will plan is ideal for almost anybody and everybody out there. Everyone should have a simple will plan in place. For many of my clients, they should also do a legacy trust plan. There's really just no drawbacks. I mean, every time I go through a legacy trust plan, every one of my clients are like, what's a downside? There is no downside. You're avoiding probate. Your spouse and children don't have to deal with probate. And when those individuals, the beneficiaries of your estate receive that inheritance, they're receiving that protected from their future creditors and their future spouses, which is a big deal. It's something that we're always looking at from an asset protection standpoint today for ourselves. But if our family, our parents, or someone giving a gift to us can do that for us, why wouldn't you? For asset protection family LLC planning, again, if you're over 30, if you have an estate over $30 million, or if you're in a high liability profession, then you should look at this. You should also look at it if you're early on in your your wealth creation, to avoid the hurdles that you're later going to see. But again, at that point, most people are more focused on building wealth and not about protecting it. But again, when you get to that point, there are things you can do, and there's never a wrong time at that point to not look into asset protection and family LLC planning. Are there any questions out there?
Anish here, right? So on the family planning, right? Isn't it that estate planning is like 11.1 million or 11 per individual? It's up to 15. That's why I said 30 million. So you're looking at about, it's 15 million per person, 30 million as a couple. Okay. So that's 11.1 million or whatever to 15 million now. And so for many of you, I didn't think I mentioned this before. The reason the number was 30 million is currently the current estate tax exemption is at 30 million. So if your estate is under 30 million, if you were to pass away, your spouse were to pass away and transfer their assets to the kids, it would transfer tax-free as long as it's under 30 million. Anything over 30 million would be taxed at, I think it's almost at a 45% tax rate, estate tax rate. So that's why people who have an estate over 30 million should definitely look at doing asset protection and estate tax protection planning. And does that cover life insurances or no?
That includes life insurance. Yeah, so it's everything. So, and when I say everything here and overseas. So if the value of your estate here and overseas is over 30 million, then that's subject to estate tax.
And when you are writing the family or any of these wills and trusts, right? Does it protect from India, like overseas also? Is part of it, or
Unfortunately, no.
India doesn't recognize our documents. So, India is tricky, right? Because my first recommendation to my clients always is to make sure you have a will in India. But I'll be honest with you, sometimes a lot of times with my clients, if they have children my age or they have children that grew up in the States, it might be better to start transferring assets out, or not out of India, but transferring assets over to the kids. Just because I've heard so many horror stories about people trying to transfer assets, and when they have kids or individuals who have grown up in the States, not knowing how the system there works. Anyone else questions?
Hi, this is Raghu. Quick question. You mentioned about irrevocable trust. Why not about the revocable trust estate, just so that you can, the owner has the grantor still has the control?
Sorry, what's your question again?
What's the difference between a revocable and irrevocable trust? Revocable, you should be able to change, right? You mentioned about having an irrevocable trust. That's why we need a family LLC. Why not have a revocable trust so that you can change your assets in and out at any time?
Sure. So the big difference between revocable and irrevocable trust is the revocable trust, you can change the terms, you can change the move assets in and out, you can terminate the trust whenever you want. With an irrevocable trust, you can't, once you set it and once you move the assets in, you can't change it. You can't change the terms of the trust, you can't change you can't take assets in and out of the trust. And the other thing is, whenever people are asking about irrevocable trust, they're usually asking me in the context of, hey, if I set up an irrevocable trust, can I protect my assets from creditors? And while an irrevocable trust can protect your assets from your creditors, you have to give up control, and you can't be the beneficiary of the trust. And so that's the biggest disadvantage with using an irrevocable trust, is just an asset protection tool by itself, because you're technically giving an asset away. So yeah, your creditors aren't going to get to it, but you can't use it either.
Yeah. So in the early stages, do you recommend, when people are making maybe investments and all that, you recommend having a revocable trust?
A revocable trust, yes. A revocable trust I would recommend all the time. Just for the two parts of one, your spouse and your kids are going to avoid probate. But two, when those assets actually come down, and the way, it all depends on where the revocable trust is set up, right? The way our revocable trust is set up, when that asset comes down to your children, to the surviving spouse, and to the children eventually, it's protected. It's protected from their creditors. It's protected from their spouses. And we can set it up where they can still control it, they can still manage it, but it will always be separate and protected from those two potential threats.
Okay, great. Yeah. And also, I have a couple of questions. Just one question on the rental property, like as an investor, right? That's the main thing about protection. I have like LLC, series LLC that I'm trying to create. I have personally right now currently rental properties on my name. And as it's a liability, I'm trying to move it to an LLC. But the due on clause, and they talked about that sometimes if you have a loan, that's an issue. So I read something about land trust. So create a land trust, deed it to the land trust, and then make the land trust like the beneficiary, the LLC as your beneficiary, so that you still get your protection, but the land trust will be having the deed. So I just wanted to understand, have you seen that? Is that stuff necessary?
I have to go back and look at it. So I did look at it a couple of years back. I don't think it provides a protection that everybody puts out that it does. Believe me, otherwise I would know about it. But I can go back and look at how that's do you remember the kind of the details of how the land trust works?
Yeah, but basically the land trust is to avoid sometimes when you change the deed, avoiding taxes and the due on sale clause. So when you have it, and then you have the land trust, the member beneficiary is still your LLC. So you're still getting the LLC protection from that, but makes it easy to do a transfer with the land trust instead of changing the personal property to LLC deed, change it to the land trust.
So you're saying the LLC would own the property, and the property and the LLC would be owned by the land trust, or
No, LLC would be the beneficiary of the land trust. The deed house, the personal deed is transferred from my personal name to land trust. And the land trust, basically the membership, the beneficiary would be your LLC, the membership interest will be in the LLC. So that because the land trust by itself does not give you, if it's still on your name, you're not getting any asset protection. If somebody sues you, then it comes to your name. So you still need a LLC to have a protection. And so the land trust would be, the beneficiary would be the membership interest, and that would be, the beneficiary would still be LLC, so that you're still getting the protection of LLC.
and would the trust, would this land trust, would that be is that a revocable trust?
Yes, yeah.
So if it's a revocable trust and someone were like slip and fall on that property, from a liability standpoint, that revocable trust, I mean, you go straight to the guarantor for that trust. So I don't see. There's a couple of things there, because the other part is I've never seen an LLC the beneficiary of a trust before. I don't even know if an LLC can be the beneficiary of a trust. I'd have to look more into that, and I don't mind taking a look at it. And maybe
I was looking at, because some of the things like online, like Anderson Advisors, and they were talking about land trust. This is one of the, I want to make sure transfer whether LLC, because that looks like an extra step. Is that worth it, or just deed it to LLC, all my properties, deed it to LLC?
I really haven't seen much in Texas. I have seen, Chris, are you on? Chris Parsons, my partner, on here as well. I've seen land trust in California. Chris, have you come across land trust before?
Yeah, I've seen people use them in California a little, and then there's one other state where I saw them. It wasn't Texas, I can't remember, but
Florida uses land trust a lot.
My understanding with those, their land trusts are used more for tax purposes, especially like state income tax purposes, than it was for asset protection. But that's why I feel like you see more of them in use in Florida and in Texas. I mean, Florida and California than you do in Texas.
So you are normally, the way you advise for the asset protection is to move the properties to LLC, deed it to LLC, and then that provides the protection.
Absolutely. I mean, so the first line of defense is always moving that rental property into an LLC. And I'm not even talking about the family LLC, but just an LLC.
Yeah.
At least to protect your personal assets from the liability of that property.
Okay, great. Thank you. Appreciate that.
this is not like the series LLC, right?
Series LLC is, it is Series LLC. You can have Series LLC. Series LLC is nothing but just trying to have multiple like filings. You have a master LLC and you have a series underneath. So each property has its own protection, but your master LLC, you're only doing one taxes. It's just a different form of LLC that you're doing.
So the purpose of the series LLC is, like instead of doing five, let's say you have 5 rental properties, instead of doing 5 different LLCs, you can do one series LLC, and each rental property would be in a separate series. You just have to be careful with them. I know my partner at Shamir, we're talking about sometimes there's issues from a lending perspective. Lenders don't like series LLCs. The other part is remember, you're setting this up so that way if there's a loss, if somebody slips and falls on property 1, they can't take property 3 or property 4 or any of the other properties, right? However, you have to be, the rules regarding series LLCs are very strict, and the protections for series LLCs are really strict. So one of the things you can do is you got to treat them as individual businesses, like separate businesses. So one of the things that my clients always slip up on is, they'll pay that, they'll be out and about and they have a contractor they got to pay. They're a rental property 1, right? Well, they don't have the credit card for rental property 1. They have the credit card for rental property 3. So they just go ahead and pay it. Well, that's not keeping the business separate. That's commingling the funds, right? And so those are things that clients get tripped up on, which they wouldn't if they're just in separate LLCs. So I always recommend to my clients to keep them
I know people don't want to spend the $600 for the LLC, but I always recommend just keep the LLC separate because you're allowed more mistakes when they're in separate LLCs than you are when it's in a series LLC.
Yep, thank you.
Yep. Any other questions?
Hey, Anish. Yes, I was gonna say, how do you usually, if we want to work with you, like, is there like a consultation first, and then you give the plan, what to do?
Yeah.
Okay.
Yeah.
And that, the other part of the question, if you please can also share your contact information, and that would be great.
Yeah. So 100%. So what we do is we do a consultation. Because a lot of times, people say, well, you should figure out who your executor should be, your trustee should be, which plans you want to go with. I'm like, don't, and that usually people get caught up in that, right? And they won't go actually do the estate planning because they're too worried about, well, should I name this person guardian? Should I name that person guardian? Should I name this person executor? Let me help you with that. I've seen, again, I've done a lot of estate administration. I've done a lot of estate planning. And I can tell you from experience, what's good and what's not to get, what's not good. So we set up a consultation. Once we go through the consultation, we go through your options. We talk about potential individuals that can be your executor or trustees. And then you'll go home. You're not going to make a decision that day as to who's going to be the guardian or the executor. You go home, and typically the consultation is with your spouse as well. And then you go home and you go over this. We have an estate planning questionnaire. And then typically you come back and you have additional questions about maybe a trustee or a guardian or executor. We go through that. And then once we finalize the questionnaire, we take that questionnaire, start preparing your documents. When the documents are done, you come in, sign the documents. We take those documents, we scan them in, create a binder for you. Our estate planning binders have basically a copy of all the documents in there. They have a summary page explaining what each document should do. There's a section in the back that has instructions for the executor and the trustees on what they need to do if something were to happen. There's also a section in the back where you can list all your assets. Because I can tell you with estate administration, the biggest headache is always trying to figure out what all assets are out there. For a lot of you guys know where your assets are, what your assets are. But when you're gone, does your spouse know that? And usually that's the most difficult part. There's a lot of things that they don't know. There might be investment here or something you guys saw online that you guys invested in that there's no paperwork anywhere, right? Unless we go through thousands of emails, right? So I always tell my clients, go through that binder and go through that last section and list your assets. Make sure your spouse is involved and they know what's going on, because probably the most difficult estate administration I do is whenever there's a spouse who has no idea what the finances of the house.
Yeah, that makes sense. Cool. Thank you.
Yeah. Any other questions?
One question on the business, like the S corps and all the stuff, right? Do we need to create a trust for that, or how does the S corporation or any of the other LLC, right, can be part of a trust?
Sorry, what was your question again?
For the business related, right? If you have a business LLC like an S corporation or an investment LLC,
Yeah.
you need to create an individual trust for it, legacy trust if you need it, or can it be part of the same legacy trust?
No, it would be all part of the same legacy trust. So the way it would be is that the way it would be set up is you have one legacy trust for you and your spouse, right? And that legacy trust would own all of your underlying assets. And so we transfer all your existing LLCs and businesses to that trust. And then in the future, when you're setting up a new LLC, you would set it up under the name of the trust. So any new LLCs, any new entities that you create, like corporations, LLCs, or partnerships, it would all be in the name of the trust. And if you're ever buying, you're investing in a partnership or LLC, that would go under the trust as well. Does that answer your question?
Yeah, to a certain extent, but yeah, I think we probably need to talk a little deeper on that. But yeah,
Okay.
Thank you.
Yep. Anyone else? Yeah. I guess that's all the questions. Lillian, what's the best way to go ahead and provide my information to everyone?
Yeah, so we can provide it in the REF WhatsApp, or the app as well. Just drop it in there, for everybody to be able to reach you. So yeah, I mean, like, we could just spend the next couple of minutes, just I'll ask some questions and kind of stir the pot a little bit if that's okay.
Sure, go for it.
Okay, great. All right. So, what are some of the biggest mistakes specifically in real estate investors make when it comes to real estate to estate planning?
Oh, well, usually the best is setting up the estate plan, setting up a revocable trust plan, and then not transferring assets over. They set everything up and they continue going down the path and they put everything in their name, and so you're missing out on the biggest benefits, which is avoiding probate. And if you don't put it in the trust, you got to do probate.
Yep. Well said. Okay. And what are the common ways investors accidentally expose themselves to liability?
Or the common ways? Well, one, by not using a business entity. A lot of times, so a lot of my guys with rental properties, they'll put those under an LLC. But a lot of times when they're buying raw land, they're not. So they think, okay, well, it's just raw land, so I don't need to worry about it. But who knows who's going on that property, who could trip and fall on that property. So not putting in business, any kind of real estate or any kind of assets into a business entity is probably the biggest mistake most of my clients make.
And what are some strategies people can implement now to reduce long-term tax burdens?
Long-term tax burdens. So one of the other things that people don't realize with estate planning is that there's what is called the step up in basis. And that is the ability where when you pass away, and again, this is probably too long because at that point you've already passed away, but when you pass away, any basis that you have in a property gets a step up in basis. So if you buy it at 100,000, when it gets to your beneficiaries, if on the day you pass away it's worth 400,000, then that property gets step up in basis from 100,000 to 400,000, and that beneficiary gets it with the step up in basis of 400,000. But something that a mistake a lot of my clients make is that, a lot of times they start doing planning and they start doing gifting and they're like, okay, well, I'm going to start gifting these properties to my kids and my grandkids today. Well, the problem is when they make those gifts today, if you're making a gift today, as opposed to making a gift on death, you'll lose that step up in basis. And which is a big tax benefit. So, I would probably say that's another big mistake a lot of clients make, when they're making gifts is they're not properly educated on the fact that you could lose the step up in basis.
All right. And how does proper planning affect the ability to raise capital or bring in investors?
That's a great question. So, and I did forget to mention this, but I do a lot of estate planning and asset protection planning for clients. But the tricky part, when I'm doing asset protection planning for a physician, it's not tricky. Their biggest potential liability is personal lawsuits for malpractice, right? With my business guys, their biggest potential liability is typically the lender coming back, right? However, if you're doing a lot of asset protection planning, you're setting up this asset protection planning, and then you go out to borrow money, well, guess what the lender sees? The lender sees a lot of asset protection. And then the lender's like, well, wait, you want a loan from me, but if I try to collect from you, I'm not going to collect. So I'm not sure if I really want to make this loan, or this asset protection makes my lending a lot more difficult, which makes the pool of lenders smaller as well. So it's just something to be aware of, that yes, I understand that a lot of my business owners want to do asset protection planning, but remember, if you're still going to be going out there and asking for money from lenders, well, it kind of there's conflicting purpose there.
What are what should investors be thinking about when it comes to leasing and tenant related liability?
Leasing and tenant related liability. What do you mean exactly? Really the main thing is make sure your leases are really on point and your protection. I mean, from a liability protection. But the other part is just making sure you're either, again, that property's in an LLC, or you're making sure you have the proper insurance in place to cover yourself.
That's something that you help with, of course.
We do.
Outstanding. Okay. And if someone, all the people that are listening today and realize that they're not protected as well as they should be, what should their first step be in getting documents using an app or a Google spreadsheet? Like, what are some high level things to prepare for when starting to gather everything and talk to you?
Two things. One is to get a great proper inventory of assets, and that helps us determine what can be protected, what can't be protected. The other is to get a good idea of where your potential liability is. Are you worried about the guy that you had in a car accident with suing you, or are you more worried about the lender? Are you worried about a tenant suing you? Because in many situations you're already protected. Like, a lot of times clients come to me and they're like, well, I'm afraid that my tenant will sue me and they're going to go after my personal assets. And I'm like, well, you have an LLC in place. So that right there is why the reason why you have a business entity in place in the first place is to protect you from that liability. So it's really about, what liabilities you're worried about. And then it's, at that point, it's a balancing act, because asset protection is not simple. There is additional work involved, and it is more administrative work. So it's a balance of all the administrative work and the freedom that you have, because you have to give away some freedom when you're doing asset protection.
Right. Big trust exercise.
Yep.
Trustful.
Yep.
So, how can someone protect themselves when doing multiple deals at once?
When viewing?
When doing multiple deals at once.
Multiple deals at once.
And or in multiple states and countries as well.
Well, one, having the proper attorney in place, making sure that they're aware of the laws where you're doing the deals at. Really just making sure they're separate. You keeping them separate. You're not commingling anything, to protect them from the good ones from the bad ones, the good deals from the bad deals.
Right.
Yeah.
Do you want to go into some of the different states and like how they differentiate, in terms of, because are some of the people here, like I would assume, are doing deals, not just in Texas, but, in other states, like, and the benefits of doing business in Texas and filing in Texas? Like, what are some of the things that like that are, I guess you could say, like,
Sure.
Texas friendly,
Yeah.
Yeah.
So one of the biggest thing is luckily we're in the state of Texas. Texas is probably the most asset protection friendly state of all the states. It used to be Florida, until a judge down there kind of screwed up the whole family LLC asset protection by misinterpreting the law. But Texas is not. Texas is still rock solid about it, and it's probably one of the best states from an asset protection standpoint. We did talk about it, or I guess during the presentation I was talking about irrevocable trust and how there's no magic trust. I gotta walk that back a little bit. There are two states that have what are called asset protection trusts, where you can put assets into a trust and benefit from it and control it. However, there are hefty fees attached to it. Delaware is one of them. Alaska is the other one. They both have asset protection trusts where you can't put assets in. You can stay the beneficiary. You can stay the trustee. You can control the assets of the trust. But you do have to have a Delaware trustee or an Alaska trustee as either a co-trustee or the sole trustee attached to that trust. And normally those trustees, they're corporate trustees, and they charge a hefty fee for it. So I think there are better ways of doing it. I think with a family LLC and a children's trust plan, you can basically get the same benefits without spending that much money on a yearly basis. Yeah.
Well, before we conclude, does anybody else have any other questions? All right, super. Okay, well, Anish, thank you so much. That was incredibly valuable and honestly probably saved a few people in this room from very expensive mistakes down the road. For everyone here, this is one of those areas where waiting doesn't make things easier. You know, it just makes them a lot more complicated. So if anything today made you think I need to handle this, this is your sign. And to contact Anish and get the ball going and set up a meeting with him and help him, implement the steps that we can all take care of starting this month. And we'll make sure you have a way to connect and take the next step. And thank you again for being here, and thank you, Anish, for sharing your expertise. And
Thank you.
this was one of the best REF webinars.
Thanks for having me.
We're all great, but that was yes, we appreciate you. All right, guys. Well, thank you all for joining, and thank you, Anish. And I look forward to meeting you in person and at the next REF event.
Sounds good. Thank you, everyone.
All right. Y'all take care. Bye.